We have been deliberate. If the Bill of Rights doesn't apply anymore, if the Act of Supremacy doesn't apply anymore, then Parliament should have expressly repealed them and said so. Instead, what they've done is they've enacted treaties which are, in my view, illegal under the existing constitutional act. And I'm sorry to say it, but our own sovereign, the Queen, has been complicit in that and has given her royal assent to things that she should never have assented to. And and our own laws now are completely ignored. I sat in a, if I can digress slightly, I sat in a VAT tribunal with one of my constituents who had his car, his cigarettes and his alcohol taken away at Dover. And he wanted to be charged with smuggling or to have his property back. And I sat arguing the case in the VAT tribunal with him on various occasions over 2 years. At the end of that, I said, "Are you officers of the Crown?" And they didn't answer. I said, "You're sitting under the Queen's coat of arms. The Bill of Rights says that you cannot take someone's property away without a conviction in a court. And you are obliged under the Bill of Rights to hold that above all and other statutes." They completely ignored me. They found against my constituent. I had a drink with a very senior policeman after that, some time up, and by chance this came up in conversation, and I was telling him about it. He said, "Oh, I know all about that." I said, "How do you know about it?" He said, "It was on our internal bulletin." I said, "Why was it in your internal bulletin? Was it because I was right?" He said, "Yes, of course you're right. But they're not going to find in your favour, because that would open up every other case that anybody wanted to bring and claim their property back." So we know that our existing laws are ignored in our own courts because it doesn't suit what the politicians want, and that is a very dangerous situation to be in. So what's happened to us has been unconstitutional throughout the whole process. Now, the worst of all, of course, is the political system. I said we believed, or we had trust and faith in a common political system, a parliamentary democracy. That's been completely subverted. Most of our laws now are actually made in Brussels. The Germans did a study in 2006 under one of Roman Herzog, one of their former presidents, I believe, who calculated that about 84% of their new laws actually came from the European Union and not their own national legislature. And he questions whether Germany could actually be called functioning democracy, given that fact. Our own government, of course, would never publish such figures because they don't have the honesty to do so. But I sit in the legislative sausage factory 4 days a month in Strasbourg. There is an endless avalanche of legislation, usually incompetent and unnecessary, but that's where the laws are made. Many laws now which are enacted in Parliament are done because they are required to be done because of EU directives. And this is how they seek to hide it. When they pass idiotic legislation, it's because they have to. And rather than admit it's idiotic, they actually pretend that we need it, but they're obliged to do it. We do not live in a democracy anymore, in my view. You cannot call it a democracy when you are obliged to do things by what is essentially a foreign political power, which is the European Union. Now we then come on to the legal system. Now my first period in the Parliament, I sat in the Security and Defence Committee for 5 years, and I watched how they are creating common European armed forces. Everybody denies it isn't really happening, but of course it is, because we can see now that, I'll say that a bit of this in a moment, how Cameron has now signed up to a deal with the French, where we're going to share navies. That'll be an interesting thing to watch. But they're doing this by means of common communication systems, common command and control structures, and common procurement policies. And what they're going to end up with, as it says in the Lisbon Treaty, is a common security and defence policy with a common defence. Well, I don't know what you call a common defence, but I would call it armed forces. And that's where they intend to end up. I now sit on the Civil Liberties, Justice and Home Affairs Committee, and I can tell you that they are building a system of common EU common criminal law, a criminal law system. Now this is being done by various instruments and various institutions. The institutions are, for example, the European Public Prosecutor that's being created. They've got Europol, which is the European Police Force. They've got the Euro Gendarmerie, which is the paramilitary police force, which we're not a party to yet, but we will be eventually, I'm sure. these different institutions, and the European Police College, which is headed up by an ex-communist policeman from Hungary, who seems to be the ideal kind of person to do that kind of thing. They need their own secret policemen, so let's recruit some that have already done the job. And he said recently that the Europol must have executive powers, meaning the power to arrest people, and that's rather than just advise national police forces. That's where it's moving. And then you've got the instruments. Now, the one that people have probably heard about more than any other is the European arrest warrant. I wrote about this right from when I first became an MEP in 2004. I warned about the dangers of it, and we've seen all those dangers actually now start to come to pass. Under a European arrest warrant, there are 32 categories of crime that you can be extradited for. Some of them are not specific criminal offences in the UK. For example, swindling and corruption are things that you can be extradited for. Well, some people might take the view that many members of the House of Commons and Lords are corrupt swindlers. But under English law, you have to be charged with a specific offence, but not in a European arrest warrant. It is a category of crime, and it can be for investigative purposes, because obviously, as I'm sure there are lawyers in the audience there will know, under the English system, we've all seen Dixon and Dock Green and the Sweeney and the Bill. The police investigate a crime, they gather the evidence, they take the suspects, they arrest the suspect, they charge them, and they're taken to the magistrate's court where they're either remanded on bail or in custody. On the continent, it works slightly differently. An investigative magistrate can decide that somebody may possibly have been involved in a crime. They can arrest them and have them in prison while they investigate the crime. That can go on for months or even years. And at the end of that process, they may not even be formally charged. They may be released. But meanwhile, their life may well have been destroyed. Under the European arrest warrant, the courts in Britain have no power to prevent extradition. It's become a bureaucratic formality. And I've sat through court cases now where defendants and their families have been absolutely stunned by the fact that the court has no power to take into account the evidence and decide whether there's a proper case to answer or not. One of those cases, the Andrew Simeon case, you may know about, was the Greek boy that was charged. Well, he's an British citizen, but of Greek descent, who was charged with manslaughter. He went all through the appeal court, and all the indications were the evidence had been fabricated against him, that statements had been beaten out of witnesses, who immediately withdrew them with the British consulate afterwards. The judges in the appeal case knew something very fishy was going on with this case, but they had no power to prevent it. So what they decided, I thought was quite good at the time, they said, it appears that there's something wrong with the way this evidence has been gathered. Does it amount to an abuse of process of the European arrest warrant? We can't decide that, so we're going to refer it to the House of Lords to ask them. And I said to the boy's father and the lawyer afterwards, I think that's a very good move, because they've now made it political. It's now not so much a legal question, it's a political question. Is the House of Lords prepared to let British subjects be extradited when it looks like the police in a foreign country have cooked up the evidence? How wrong could I be? In what I think was one of the most disgraceful and disgusting decisions that the House of Lords ever came to, they decided not to even review the case because it wasn't in the public interest, or whatever form of words they used. The boy was extradited. He's now spent, this will be his second year in Greece, 11 months of it spent in one of the worst hellhole prisons in Greece, all because British courts have been completely stripped of their power to actually protect British citizens from unjust arrest and imprisonment in a foreign country. And anybody that knows me well will know that I'm hardly soft on crime. I want to bring back hanging, but the law is there. The law is there to protect the innocent as much as to convict the guilty. That's where we are on the European arrest warrant. There are other things that have come along, like common recognition of fines and confiscation orders, and a whole raft of instruments which will subjugate our legal system to the continental system. Now, who is responsible for all this? Well, the answer is simple. It's all the political parties that have sat in Westminster for the last 40 years. And this is going to continue under the so-called Conservatives in the coalition government. There are three things I could mention. First of all, as soon as the coalition government was formed, Theresa May formally signed up to something called the European Investigation Order, which is another instrument of the legal system. That's still in its draft form. It hasn't